Now, Dr. Michael on in here again, and Bernard, the barrister there. And this video is called Where Have All the Attorneys Gone? Yeah, Bernard remembers the old song, Where Have All the Flowers Gone? And I didn't think you were old enough to remember that song, Bernard.
Oh, I remember really well.
Oh, he remembers it very well, he says. It was a very big hit some years ago. But anyhow, we're not talking about that. We're talking about where have all the attorneys gone?
Hollywood.
Then it says Hollywood. Yes, that's true. If you've ever seen a Hollywood movie involving a lawyer, and so many of them do, you will know that that lawyer is always referred to as an attorney. So why is it that in America, which is an American term for attorney, but why do they have the term attorney for a lawyer there, but not in Britain? Instead of that, we have barristers, of course, and solicitors, but we don't have attorneys. What happened? Well,
Power of attorney?
Well, Bernard correctly points out that we do still have the word attorney used in a slightly different sense, referring to a power of attorney. And someone appointed, given a power of attorney, is not a lawyer. They could be, but mostly they're not, and they certainly don't have to be. You can appoint anybody as your attorney in that sense by giving them a power of attorney. It's got to be a written document, power of attorney. It's quite a formal document. And you can either give them a general power of attorney to act on your behalf in every respect, or a special power of attorney which gives them limited powers to act on your behalf. This is used if someone is abroad or away for a long time, or for one reason or another can't attend to their own affairs. If they lack mental capacity, and that's the reason, or they're likely to, or they're afraid they may, and that's the reason they want someone appointed with a power of attorney, that's a different type of power of attorney, and that is now called a lasting power of attorney. That's quite a different type of power of attorney. Again, the person appointed as the attorney will not be a lawyer normally. It used to be called an enduring power of attorney, and that was changed to lasting power of attorney in 2007, because the original type, enduring power of attorney, was open to abuse. wasn't well thought out at all, like so much in our law, I'm afraid. And it's got to be set up while a person still has full mental capacity, but it only kicks in once they lack mental capacity. It's quite a complicated thing. But that's nothing whatsoever to do with the use of the word attorney as a lawyer, which is the case in America and many other countries around the world, and used to be the case here too. So why no longer? Well, and the word attorney, what does it really come from? What does it mean? Well, it comes from, via the French, basically from a word related to the word turn, taking your turn. In other words, someone taking the place of another, someone acting on behalf of someone else, stepping into the shoes of somebody else. That's really the concept behind attorney. And of course, American attorneys do that. And we used to have attorneys here in this country, the United Kingdom. But in 1875, the attorneys got together and decided they would have their own institute, their own association. For many, many centuries, they'd been knocking on the door of the Inns of Court, which is where barristers traditionally were trained, still belong to the Inns of Court. Now they are very much a barrister preserve, and these attorneys were always shown the door. Always, none of them were ever allowed in to the Inns of Court. And eventually, after many centuries, they decided, well, we can't get into the Inns of Court, so why don't we start our own equivalent institute? And they called it the Law Society, which is still going now. But when they first met to arrange it all, they said, well, we realize that the word attorney in this country, in England, the word attorney just has such a bad reputation for dishonesty that we can't use that term anymore. And so because they were in such bad odor with the public as attorneys, they decided they would not use that term anymore, which is a very honourable term, but it didn't have very good associations back then. And instead they chose to call themselves solicitors, which was a small branch of their profession, really a trade, which dealt with the Chancery Court rather than the Queen's Bench or King's Bench Court. Chancery, a much smaller branch of their profession. The solicitors at that time didn't have a particularly good reputation either, but was not as well known. So therefore they decided that from now on, instead of calling themselves attorneys, they would call themselves solicitors. Well, there's got to be something very wrong if you give up an honourable sounding designation like attorney and replace it with the word solicitor, which really means a tout, somebody persistently trying to get your business or getting something out of you, which is how it's still used. That word, solicitor, is still used in that way in America. So that if you go, for example, to LAX, Los Angeles Airport, when I was last there, they were still repeating and repeating a message, which I've heard many times over the years, saying, do not give your money to solicitors. This organization does not support their activities. Do not give any money to solicitors. And that means solicitors in the sense of touts. Well, there's something very wrong if you have to give up an honourable title like attorney for one which basically means a tout, someone soliciting. And of course, soliciting is also associated with the oldest profession, i.e. prostitution. So it's not a very good word, really, solicitor. There's got to be a very serious reason why you would resort to calling yourself that instead of attorney. But the result is what we have today, that in this country, I'm talking about England now, because Scotland is different, but England and Wales, there is a very large number of solicitors compared to the number of barristers. The main difference being barristers have rights of audience in all courts. Solicitors don't. Solicitors have rights of audience only in the lower courts, unless they get a special certificate of higher rights of audience, and then they can also appear in the higher courts. But in fact, it's no longer necessary to come through a solicitor to hire a barrister, to instruct a barrister. That used to be the case, and a lot of people still don't realize that it's no longer necessary. You can come straight to a barrister now, and it still hasn't sunk in with a lot of the public, although it's been going now since 2004, nearly 20 years. But most, I wouldn't say most, but a lot of people still seem to think that you have to go through a solicitor first, and what that does is increase the costs of anything you're doing in terms of law. And it's one of the reasons why legal costs are so high in England, which is something I have touched on in previous videos, especially court cases. If you go to court and you have a solicitor and a barrister, you're having to pay both of them. The solicitor, who does not normally even come to court anymore, they used to come and sit behind the barrister, now they don't even show up normally, their bill is usually by far the higher of the two. The barrister who actually represents you in court is then paid through the solicitor. But that's no longer necessary. You can come straight to a barrister. This two-profession model is one of the reasons for the very high costs of litigation in this jurisdiction. I'll say more about this whole business in another video.